Did you know that in 2025, over 60,000 immigrants in Australia were suddenly hit with new restrictions without any public warning? That's right. Overnight, laws changed. And for many, it felt like the rules of the game were rewritten while they were still playing. Imagine arriving in a new country full of dreams, only to be told you can't work remotely, can't study your chosen course, and even posting on social media could get your visa canceled. Sounds unreal? It's not. These aren't just rumors. They're real, enforceable bans already affecting people across the country. From silent surveillance on your Instagram to blocked paths to permanent residency, these changes are big, and barely anyone's talking about them. So what exactly are immigrants being banned from doing in Australia in 2025? Stick around. Some of these might shock you, especially if you're already living there or planning to move soon. Number 10. Banned from moving interstate without notification. Imagine you've settled into a comfortable life in Sydney, but a new job offer pops up in Brisbane. Better pay, better lifestyle, and a chance to finally grow your career. Naturally, you pack your bags and move. Seems like a normal decision, right? Well, under the new 2025 immigration law changes, this could now be considered a breach of your visa conditions. Yes, you heard that right. Certain visa holders, especially those on temporary work, regional, or skilled migration programs, are now banned from moving interstate without first notifying the Department of Home Affairs. That means even something as simple as relocating for work, school, or family reasons could put your visa at risk if you don't follow the correct steps. The government introduced this rule to keep track of regional visa holders who are supposed to live and work in specific areas to help balance population and workforce distribution. But the reality is, many immigrants are caught off guard. They don't realize that a personal move could lead to legal trouble, or worse, visa cancellation. This law has already affected hundreds of visa holders who unknowingly violated their conditions simply by changing their address. And the scary part? The system is now more connected than ever. Your tax records, superannuation, and even rental agreements can trigger alerts if your location doesn't match your visa terms. So what should you do? Always double-check your visa subclass conditions through the Vivo system, and if you plan to move, submit a notification form online before you relocate. It's a small step that could save you from a major immigration headache. Backhand index pointing right if you're finding these updates helpful. Hit that like button and subscribe for more real talk on immigration, law, and life abroad. We've got more coming that you won't want to miss. Number 9. Ban on starting businesses without local partnership. Starting your own business is often seen as the ultimate pathway to freedom, especially for immigrants looking to build something of their own in a new country. But in 2025, Australia introduced a major legal change that's put a serious roadblock in the way of that dream. Under the new regulations, certain visa holders are now banned from registering a business unless they partner with an Australian citizen or permanent resident. That's right. If you're in Australia on a temporary visa, including popular ones like student, graduate, or skilled temporary work visas, you can no longer launch a business solo. The government argues this move is designed to prevent visa misuse and ensure compliance with tax and employment laws. But for thousands of aspiring immigrant entrepreneurs, it's a frustrating and unexpected barrier. Imagine spending months developing a business plan, securing funding, and building your brand, only to be told you can't legally register your company unless you team up with a local partner. And this isn't just about big businesses. Even small-scale ventures like online stores, food delivery services, or freelance consulting are now affected by this rule. In fact, registering an Australian business number, ABN, without the right visa conditions can lead to visa cancellation or legal action. And because the Australian Taxation Office, ATO, and Home Affairs now share more data, enforcement is faster and more precise than ever before. For many, this law creates both a legal and personal dilemma. Find a trustworthy partner or give up on entrepreneurship altogether. It's a tough choice, especially when your livelihood depends on it. The key takeaway? Before you start any business activity, check your visa conditions thoroughly and speak with a registered migration agent or legal advisor to avoid falling into this costly trap. Number 8. Ineligibility for certain government services. One of the most overlooked and often shocking realities for many immigrants in Australia is just how limited their access is to government services, especially under the 2025 law changes. New arrivals are now banned from accessing certain public services and welfare programs for up to 5 years, regardless of how much they pay in taxes or how urgently they need help. This includes services like public housing, Centrelink support payments, unemployment benefits, and even some medical subsidies. And while this policy has existed in some form in the past, it has now been tightened, affecting even more visa types, including those on temporary protection, graduate, and some partner visas. Picture this. You lose your job unexpectedly or fall seriously ill. You've paid taxes, contributed to the economy, and followed every rule. But when you turn to the government for support, the answer is no, simply because of your visa status. For many, it's a devastating wake-up call. This ban is part of what's known as the newly arrived residence waiting period, which the government extended in 2025 to reduce strain on public resources. While it may seem logical on paper, the real-life consequences are harsh, especially for new migrants still trying to find stability. In some cases, even applying for assistance while ineligible without knowing the rules can result in fines or visa issues. And with increasing data sharing between departments, it's easier than ever for authorities to detect violations. The best protection? Immigrants must plan ahead, build a financial buffer, and seek support through community groups or non-government organizations. Because in today's Australia, being new means being on your own, at least for the first few years, no matter how much you contribute. Number 7. Ban on working multiple jobs in certain industries. For many immigrants in Australia, especially those on temporary work or student visas, working multiple jobs has been a crucial way to survive the high cost of living. But under the 2025 law changes, that flexibility has been severely restricted. The government has now banned visa holders in certain industries from holding more than one job at a time, a move that has sent shockwaves through the immigrant workforce. This new rule primarily targets industries like aged care, healthcare, childcare, and disability support sectors where long hours and worker fatigue can have serious consequences. The official reasoning is that limiting workers to a single employer ensures better quality of care and reduces the risk of burnout. But for immigrants who rely on multiple income streams to make ends meet, the ban feels more like a punishment than protection. Imagine a skilled worker on a healthcare visa who used to work morning shifts at a private clinic and evening shifts at a care home. Under the new law, that's no longer allowed. Violating this rule could result in visa cancellation, employer penalties, or even a future ban from applying for permanent residency. What's even more complicated is that many immigrants aren't told this at the time of employment. Some only find out after being audited or flagged through tax records showing income from multiple employers. This has already led to numerous cases of unintentional breaches, putting honest workers in extremely difficult positions. To stay compliant, immigrants in these industries must now check their visa conditions carefully and ensure their employment contract explicitly states whether multiple jobs are allowed. In today's system, ignorance of the rules is no longer a valid excuse, and the consequences can be life-changing. Number 6. Limits on bringing family members over. One of the biggest hopes for many immigrants moving to Australia is the chance to reunite with their loved ones. Whether it's bringing over a spouse, children, parents, or siblings, family unity has always been one of the emotional pillars of the migration journey. But in 2025, Australia introduced stricter limits on family reunification, and these changes have made it significantly harder to sponsor relatives, even for long-term residents. The new laws place tighter restrictions on who you can sponsor, especially if you're not yet a permanent resident or citizen. For instance, while it was already difficult to bring parents or adult siblings over, it has now become nearly impossible unless you meet strict income thresholds, health requirements, and visa-specific criteria. Even dependent family members like children face more complex documentation requirements and longer processing times. To make matters worse, the number of available family reunion visas has been capped, meaning fewer approvals and longer waiting periods. For some families, the wait time now stretches beyond 10 years, especially for parent visas. In some cases, families are being told to apply for visitor visas instead, which offer no long-term stability and carry the constant fear of rejection or visa expiry. Even spouses and partners are affected. The government now requires more proof of relationship authenticity, longer periods of cohabitation, and stricter checks before approval. For couples in long-distance relationships, or those who met online, these hurdles can be emotionally draining. This policy shift reflects a broader tightening of immigration priorities, focusing more on economic contribution and workforce needs, and less on humanitarian or emotional grounds. Unfortunately, for many immigrants, it means having to choose between building a life in Australia or staying close to the people they love most. Number 5. Banned from applying for PR before 4 years of residency. Gaining permanent residency, PR, in Australia has always been the ultimate goal for many immigrants. A key to long-term stability, more rights, and the possibility of becoming a citizen one day. But with the new immigration changes introduced in 2025, the pathway to PR has become longer and more challenging. One of the biggest shifts: immigrants are now banned from applying for PR unless they've lived in Australia continuously for at least 4 years. Previously, certain visa holders, especially skilled workers or partners, could apply after 2 years of residency, depending on their visa subclass. But now, the government has introduced a mandatory 4-year minimum stay requirement, regardless of your job, income, or family situation. This means that even if you've secured a full-time job, paid taxes, and integrated into the community, you'll still need to wait it out. The aim of this policy is to encourage genuine settlement and prevent people from using quick PR pathways as a shortcut to access benefits or citizenship. However, for many immigrants, it adds financial and emotional stress. Living in a temporary status for 4 years means continued visa renewals, limited access to services, and job restrictions, all while trying to build a stable life. This change also affects those in regional migration programs, graduate visa holders, and even some international students who were counting on transitioning sooner. In some cases, people who arrived just before the law changed found themselves grandfathered into the new rules, forcing them to reset their plans completely. It's a frustrating shift, especially for those who've contributed to the economy and community from day one. For many, this extended timeline can feel like moving the finish line after they've already started the race. Number 4. Social media use now monitored for visa compliance. In a digital world where nearly everything is shared online, most people don't think twice before posting a photo, commenting on a video, or sharing a personal update. But for immigrants in Australia, those casual posts could now come at a serious cost. Under the 2025 law changes, immigration authorities have begun actively monitoring social media activity to check for visa compliance, and yes, that includes platforms like Instagram, Facebook, TikTok, LinkedIn, and even YouTube. This means that if you're on a student visa and post about working long hours, or you're on a tourist visa and share updates that suggest you're actually working or studying, that content could be used against you. Authorities are using AI-powered systems and data tracking tools to flag suspicious activity, especially when social media doesn't align with your official visa conditions. What makes this especially dangerous is how subtle the violations can be. A simple Instagram post about running a small business from home, or a TikTok video showcasing your side hustle, can be interpreted as unauthorized work. Even something as innocent as tagging your job location or updating your LinkedIn profile could raise red flags. In several recent cases, visa holders have been called in for questioning or even faced visa cancellations after immigration officers cited content from their personal social media accounts. The government argues that this is part of its broader effort to enforce transparency and prevent visa fraud. But for many immigrants, it feels like an invasion of privacy. The reality is, in 2025, what you post online isn't just for your followers. It's being quietly watched by systems designed to find inconsistencies. The safest approach? Always make sure your online presence reflects your actual visa conditions, because in today's immigration landscape, your digital footprint can speak louder than your paperwork. Number 3. Banned from studying certain courses without prior approval. For years, international students have seen Australia as a top destination for higher education, offering quality institutions and a pathway to future residency. But under the 2025 immigration reforms, not all courses are open to everyone anymore. In a major policy shift, certain visa holders are now banned from enrolling in specific courses without getting prior approval from the Department of Home Affairs. These restrictions mostly apply to high-demand and sensitive fields like healthcare, education, cybersecurity, and social work, where the government wants tighter control over who gets trained and potentially enters the workforce. The goal, according to officials, is to protect national security, manage workforce planning, and ensure only qualified, high-priority candidates are admitted into these sectors. But for many immigrants, this has created unexpected roadblocks. Imagine arriving in Australia with plans to study nursing, only to find out that your visa doesn't allow it, or that you need to go through an additional screening and approval process that can take months. This isn't just frustrating. It's financially draining, especially for those who have already paid application or tuition fees. In some cases, students have been forced to withdraw mid-course after being flagged for not meeting new eligibility rules, even if they were accepted by the university. The changes also affect those switching courses after arrival, which used to be common practice among students looking for better career paths. Number 2. Restrictions on remote work for overseas companies. Remote work has become the new normal around the world, especially after the global shift brought on by the pandemic. But in Australia, recent 2025 immigration reforms have drawn a hard line when it comes to remote work for overseas companies. Under the new rules, many immigrants, particularly those on student visas, temporary graduate visas, and visitor visas, are now banned from working remotely for foreign employers while living in Australia. This restriction has caught a lot of people off guard. Many immigrants, especially digital nomads and international students, rely on freelance gigs or remote roles with companies based in their home country to support themselves. But now, even if you're sitting in your bedroom with a laptop, getting paid by a company outside Australia could be considered a breach of visa conditions. The government's reasoning behind this policy is centered on protecting the local labor market and ensuring that visa holders engage in activities aligned with their visa purposes, such as studying or working for approved employers. Officials also argue that remote work for foreign entities makes it harder to monitor tax compliance and legal employment standards. Unfortunately, the rules are often unclear and not well publicized, which has led to cases where immigrants were penalized simply for accepting freelance contracts from overseas clients. Some have even had their visas canceled after routine audits of income or bank transfers revealed payments from international sources. What makes this policy particularly tricky is that many remote workers don't even realize they're doing something wrong. After all, if the job doesn't interfere with studies or local work, what's the harm? But under the new regulations, the location of the worker matters just as much as the location of the company, and working remotely for an overseas employer while in Australia can now carry serious consequences. Number 1. Ban on switching visa types after arrival. For years, one of the most common strategies used by immigrants and international students in Australia was to enter the country on one type of visa and switch to another after arrival. For example, arriving on a tourist visa and then applying for a student visa, or moving from a student visa to a graduate work visa. But under the 2025 immigration reforms, that flexibility is now gone. The government has officially banned most onshore visa switching, meaning you must now leave the country before applying for a different visa type. This change has had a massive impact on both individuals and the education industry. Many students, for instance, used to arrive on a visitor visa, explore their options, and then apply for a student visa once they found the right course. Now, doing that is no longer allowed. If you're on a visitor visa, you must return to your home country and apply for a student visa from there. A process that is not only time-consuming but also costly and emotionally stressful. The same applies to people wanting to transition from a working holiday visa to a more permanent option. Even if you meet all the criteria for a new visa subclass, you may still be required to leave Australia just to start the application process again from overseas. The official reasoning behind this law is to tighten border control and prevent system abuse, particularly in cases where people overstay or misuse short-term visas as a backdoor into long-term residency. But critics argue that the change is punishing genuine migrants who simply want to build a better life. In 2025, planning your visa journey isn't just important. It's absolutely essential. Because once you're inside the country, your flexibility to change course has essentially been cut off. As we've just explored, the 2025 immigration law changes in Australia aren't just a series of policy updates. They represent a fundamental shift in how the country manages its migrant population. From something as simple as moving to a different city or accepting freelance work online, to life-changing restrictions like bringing family members over or applying for permanent residency. These new rules affect nearly every aspect of daily life for immigrants. For many, these changes have brought confusion, frustration, and in some cases, serious consequences. What was once seen as a flexible and opportunity-rich immigration system is now stricter, more complex, and less forgiving. The margin for error has shrunk, and the consequences of non-compliance have become more severe. But knowledge is power. Understanding these new laws, even the less obvious ones like social media monitoring or remote work bans, can make the difference between a successful journey in Australia and an unexpected legal nightmare. Whether you're already living in Australia, planning to move, or supporting someone who is, staying informed is no longer optional, it's essential. At the end of the day, Australia remains a land of opportunity, but the path forward now requires careful planning, legal awareness, and constant vigilance. These 10 new restrictions may seem overwhelming, but they also highlight the importance of being proactive, seeking professional advice, and always knowing your rights and responsibilities as a visa holder. Because in 2025, it's not just about getting into Australia, it's about staying in legally, safely, and smartly.